Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
70?
Yes.
Telephone ends in 0466?
Yes.
All right, you can come get your things, go provide your DNA, go to the probation. We are good to go. Thank you. We are adjourned.
Thank you, Judge.
Thank you. Mr. Kangas Capitan?
I also put the
Capitan?
notice for that, and then you just show them.
We will go on the record in the matter 24 CF 17, State of Wisconsin versus Sergio Kangas Capitan. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Kangas Capitan in person with counsel Eugene Harrington. We're set today in this matter for a final pretrial, but the parties have reached an agreement and have requested it be converted today. Mr. Harrington, can you please recite the agreement for the record?
Defendant will plead guilty to counts 1, 2, and 3. Counts 4 and 5 will be dismissed but read in. Recommendation, joint recommendation, 3 years probation, withheld sentence, comply with the child support orders, costs DNA surcharge. That's the agreement. And can we also read in any charges that could take place from March until now, March of 23 until now, Mr. Schmidt?
From July of 23 until now.
October 31st, 23 is the last operative quarter.
If you do it, make sure to clarify it's criminal. It doesn't affect the child support case.
Yeah, we can do that. But again, just for this side, child support decides to come after for something else that's out of our hands.
Fair enough.
That's fair.
All right, that's the agreement that's been reached.
It is.
I have in front of me a plea question or waiver of rights form. Do you recognize the document, Mr. Kangas Capitan?
Yes, I do.
Did your attorney thoroughly go over the document with you?
Yes.
And is that your signature on the second page?
Yes, it is.
So he essentially read it to you word for word.
Yes.
You're pleading guilty to 3 counts of failure to support your child, 120 days plus 3 felonies. Is that correct?
Yes.
36 years old, 14 years of schooling. You can read, write, you understand the English language, no mental illnesses or disorders, no drugs, alcohol, or medications.
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt for these 3 counts?
Yes.
Did he go over the maximum possible penalty you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of them are listed on that first page of the plea questionnaire right there in front of you. Do you understand those rights?
Yes.
Did your attorney thoroughly go over them with you?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty to these charges, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Do you understand that that the state would have to prove, while you're pleading guilty to felonies, as such, you will no longer be able to use or possess firearms for life,
Yes.
no longer able to vote in any election until your civil rights are restored?
Yes.
All right. Do you understand the state would have to prove for count 1, failing to support, that you on or around and through March 1st, 2022 through June 30th, 2022 in Burnett County intentionally failed to comply with your child support order for at least 120 consecutive days where you knew you were legally obligated to pay said support? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
Yes.
With count 2, failure to support, the state would have to prove on or around and between July 1st, 2022 through October 31st, 2022 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
Yes.
Count 3, failing to support, the state would have to prove on or around and between November 1st, 2022 and February 28th, 2023 in Burnett County, Wisconsin, you intentionally failed to provide child support for at least 120 consecutive days where you knew you were legally obligated to pay said support. Do you understand what the state would have to prove?
Yes.
Do you understand maximum possible penalty is a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
Yes.
Do you understand that there is a recommendation for the court to place you on probation with what's called a withheld sentence? Do you understand I'm not bound to follow that?
Yes.
Said differently, I could sentence you all the way up to the maximum possible penalty for each of these charges if I thought it was warranted. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, that section called the probable cause section, where it basically says what happened and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did fail to pay child support multiple times in periods of 120 days and greater?
Yes.
Are you admitting here today that you intentionally failed to pay your child support?
Yes.
Are you pleading guilty to these 3 charges because you are guilty of these felonies?
Yes.
Mr. Harrington, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty to these 3 charges?
No.
You're doing so freely and intelligently. You're telling me you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at these matters thoroughly?
Yes.
Are you satisfied with his services?
Yes.
Do you have any questions for the court or your attorney before I proceed?
No.
Then as to count 1, failing to support greater than 120 days, a class I felony, how do you wish to plead?
Guilty.
Count 2, failing to support greater than 120 days, a class I felony, how do you wish to plead?
Guilty.
As to count 3, failing to support greater than 120 days, a class I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of counts 1, 2, and 3. Counts 4 and 5 will be dismissed and read in for purposes of sentencing. The other remaining uncharged charges that the state, the district attorney's office through the state of Wisconsin can charge you past, I believe, July 1st, 2023 till present are dismissed and read in. Judgment of conviction will be entered today. Before I ask for argument, do you have the amount that is owed and past due?
So, excuse me, Your Honor. So as of November 9th of 2023, that number was $20,551.62. The most up to date. The most up-to-date number that we have is of May 6th of this year of 2025, and the outstanding total debt was $41,536.39. And that's the most up-to-date information I have on hand, Your Honor.
Wow, in a year it's doubled. All right, okay, argument, please.
Thank you, Your Honor. So the sentence is appropriate given the crime at hand. This is a case where the defendant refused to comply with the child support order, resulting in these arrearages that are north of $20,000. I think the main goal with this sentence needs to be that we need to place conditions for Mr. Kangas Capitan, to ensure he fulfills his obligation to support his children moving forward. I believe the joint recommendation for 3 years of probation will do just that. We need him to work to have meaningful employment to actually support his kids. Given the fact that he will be on probation, this will be an incentive for him to comply with that support order, and should he fail to do so, he faces revocation on said probation. I also believe that this sentence would be in the public interest, as we want parents to engage with the child support system. We want them to fulfill their duties of having to support their children, and if they don't, they will face consequences. As such, I would ask the court to adopt this joint recommendation. Thank you.
Mr. Harrington?
Thank you, Judge. touching the three factors: gravity of the offense, character of the defendant, need to protect the public. This is an economic crime, obviously. Serious consequences. The defendant is 36 years of age. He's different than most of the folks that traipse in and out of here. He has 14 years of education. His history is as an electronic technician from until, let me look at my notes just quickly. January of 2022, he was employed, paying child support, and was faced with economic circumstances that were sort of beyond his control. He lost his job. He lost his job in part because he had child support obligations. And when he lost the job, there was a slight turn down on his industry and his occupation, and he's been unemployed for the most part since. He is self-employed at the present time. He does detailing of motor vehicles, and that's an occupation that significantly reduces when there's cold weather. He's sometimes able to charge as much as $60 up to $250 per job. He has 2 or 3 that are outstanding now, except the cold weather is impairing that. He started the self-employment within the last 5 or 6 months.
Yeah.
And he doesn't have any felony convictions. He's been crime-free for 10 years. When we were talking about potential defenses, the inability to pay is an affirmative defense. And Mr. Kangas Capitan gave me some information that wasn't relevant to the operative period of these crimes. But he's currently providing daycare for some small children. Has to be there when they get off to school and when they go to school and when he picks them up at the end of the day. That's why the self-employment is working for him. It's a function of bad luck, and he just didn't follow up with the child support agency and seek an adjustment to his child support obligation. But that doesn't mitigate the criminal behavior that or the criminal consequence that arises from that. He's working. I've stressed to him that he needs to work, to seek other employment in his occupation. Before he leaves the courthouse today, I'm going to try to get him the petition that he can file for an adjustment to his child support. And hopefully that'll reduce it to something that's more reasonable from his perspective. I know that Ms. Sangate is here and she may have a different view of that, but that's for another day in another court, and I'm not appointed by the PD to take care of that for him, but I'm going to assist him with that. I think this is an appropriate disposition. It provides for supervision and with the potential incarceration hanging over his head, that'll give him an incentive to take care of this obligation. I think this is an appropriate disposition. He's not a druggie or an alcohol crime. This is a crime, an economic crime, as I prefaced. So, we urge the court to follow the recommendation and place him on probation. Thank you, Judge.
Thank you. Mr. Kangas Capitan, do you care to make any statement here today?
Not at the moment, no.
Okay. Your attorney addressed the 3 things that the court must consider as it relates to sentencing: the seriousness of the crime. These are felonies, so that's serious. Plus, it's money to support your children, food, shelter, medical, all their needs, their clothing, all of those things. And so that makes it serious as well. I have to look at you and your character, your criminal history. I have to look at all other factors. including the fact that you lost your job and that you were homeless for a period of time, and you were having a very difficult financial period when it was hard for you to probably even support yourself. Even though you were in that situation, you still had the legal obligation to pay child support, to support your children, because you made them. They need two parents to provide the support. It's hard to raise a child, and it's hard financially to raise a child. I think the number is at $1 million or more to raise one child. So it costs a lot of money. I have to look at protecting the public, and here it's protecting your children and making sure that they have what they need to survive, at the minimum to survive. I do think the agreement is appropriate because it's going to place you on probation. So I'll order 3 years of probation. I am going to do a withheld sentence. Normally I like imposed but stayed sentences where you know what the punishment could be. But here there's a possibility of going to prison, and that could be, that is a strong penalty, but it could be necessary if you're not going to do what you need to do to support your children. So the court will do a withheld sentence, keeping the entire possibility of prison hanging over your head. I am going to order, I'm simply going to order $200 or $250, the DNA surcharge for each of these 3 counts. I'm waiving the rest of the court costs and fees. Quite honestly, I don't believe you're going to have the ability to pay them anyway, unless you first pay off your child support. That's going to take a long time for you to be able to do. And I want you to focus on paying that child support. Conditions of probation: absolute sobriety, gainful employment, to comply with whatever child support order is in effect.
Does that include, I have 2 different ones for child support, which is, I think it's supposed to be about $2,400 a month, I believe I'm supposed to be paying. So does that include both of them, or just the one in Wisconsin?
Just the one in Burnett County.
Okay.
That's the only one I have jurisdiction over.
Okay.
And so you just have to make sure that you're paying this case involving your children in Burnett County. Now, from the way you phrase that, it leads me to believe that you may not be going or paying your other case in perhaps Minnesota. You made the children, support the children, figure out how to support the children.
Yes.
And Mr. Harrington will show you how to petition to have a review, okay? And that goes, he's not going to help you probably with Minnesota, but it's very similar.
Yes.
Do the same thing. All right. These are felonies: no use or possession of firearm for life, no voting in any election until your civil rights are restored, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am going to order, well, at minimum, you have to pay an amount back, and it's not just complying with child support. I don't know what the child support order is going to be, but I have to set a restitution amount, because is he stipulating to that amount, or is this going through child support for collections? I don't know.
Everything I got, it wasn't the $40,000 number. That just surprised me that it was 20,000 something.
My guess is that this will have to go through child support, because otherwise it has to be wiped out of their system and put into the criminal system. It's not true, then what is it? Then I need to know.
So my experience with child support is they have their own Kids for system that they track all that information for. And especially if Mr. Kangas Capitan is going to be paying from a different jurisdiction, potentially, that'd be the easiest way for them to track it. Now, if the court wants to do it through a restitution court here.
No, I do not.
Okay.
I think it should go through child support, because child support will be monitoring, and child support will be knowing that it's out here and that he has prison hanging over his head. And if you don't pay, child support would probably want a purge agreement with you, and all of those things. So just pay your child support at minimum with the court costs and fees. I am going to order that you have to pay $25 a month at minimum. If you fail to pay, not only will the court enter a civil judgment against you, because you're always going to owe it, But the court could issue a warrant. You could sit up to 6 months in jail. That's on top of or aside from any jail time or prison time you could sit for this crime and or for any contempt found in the child support cases. Figure that out. I believe that covers everything, Mr. Vila.
I believe so, Your Honor.
Oh, there's $1,000 that's posted here. I'm not going to have it taken for court costs and fees. I'm directing that be transferred to child support to cover some of your past due arrears. Okay? Anything else that I'm missing?
May he begin payments January 30th, 2026, the court payments?
Why January 30th? Just to start in February? I'll stay it until February, then you're gonna have to start making your payments, okay?
Thank you,
For
Judge.
your court costs and fees, not your child support. That you have to get on and pay right away. So if you fail to make your December payment, you could be revoked and you could be in front of me for sentencing. So start to make your payments and make sure that it gets taken care of. Thank you.
Did you keep your copies of these things?